trust me, I mean, I understand. Thanks for everybody for being here today, and I understand that it's a holiday weekend, I know. But if we don't have class today, what it does is push us right into Christmas. And so that's why we're all here today. And again, I appreciate your dedication. A couple things. Next week, Professor Tommy will be here to do a review of the law review fundamentals exam. I will not be here next week, so you get a break and before we get the privileges in on the 15th. Okay?
Okay.
What else? Are there other questions? That's what I don't think they're expected to have the test graded by the 10th. Okay, that's when I'm expecting the preliminary report. Oh, this afternoon, for research and writing, to repeat what I said in the email, Professor Fontana will be here to do a Westlaw introduction about how to do research on Westlaw for the first hour of class this afternoon, and then we're going to do a grammar diagnostic that will help us see where everybody is. Don't worry about it. It's not going to count against you or nothing like that. Don't panic. And it's not easy. And a lot of us haven't thought about predicate nominatives in many, many years, right? So just see how you do, right? It's totally diagnostic.
Right.
And they're also fun for me to grade.
Really?
The grammar Nazi that I am.
You're gonna give me whiplash. You're gonna give me whiplash because I'm trying to keep my eye.
Oh, well. Okay, so let's get started. Who's my scorekeeper? You're nominated. When we take a break, I gotta have a score update. You're the man. Yep.
I got you.
All right.
On the doctor. I got all.
Yeah, well.
That's what I do.
So, Big Town Nursing Home. Go ahead, Miss Savage.
Do you want me to do facts first?
Yes.
Got it. Okay. The plaintiff was Newman. I apologize. First of all, sorry. I apologize because one of my friends told me after I did all my briefs that I did them too long. So I apologize. I'm going to try to skip them.
Okay.
Okay. The plaintiff, Mr. Newman, was a retired coroner. He's 67 years of age, veteran with health issues. His nephew signed him in the initial paperwork which stated that the patient will not be forced to remain in a nursing home against his will for any length of time. In September of '68, he decided that he wanted to leave, but he was restricted from using the phone and was locked up in Wing 3, which contained mainly senile patients. After an attempted escape, he was put in a restraining chair for over 5 hours and wasn't seen by a doctor for over 10 days. Plaintiff was in prison for a total of 51 days. He ended up losing 30 pounds, which sounds like something I need to do. Defendants kept plaintiff there against his will. You know, his submission paperwork said that he would never be kept there, and they never had a court order to keep the plaintiff there. The rule states that false imprisonment is the direct restraint of one person of physical liberty of another without adequate legal justification. So the question is whether Big Town Homes falsely imprisoned Mr. Newman by keeping him against his will from September 22nd, 1968 to November 11th, 1968.
Very good.
Based on the rule, yes, Big Town Nursing Home, they were acting with intent of utter disregard of the plaintiff's legal rights and engaged in the false imprisonment of the plaintiff.
Very good. Very complete. Nicely done. So, we get it, right? Did they have to tie him up in the chair in order to be guilty of false imprisonment? No. Did he have to be committed to Ward 3 with the psychopath in order for them to to be liable for false imprisonment? No. It is enough, okay, it is sufficient that he was, kept in the home against his will, for any given period of time. Okay, even, the period of time can be brief, right? But it only speaks to damages. Okay, it can be 5 minutes, but a defendant can still be liable for false imprisonment for even as much as a minute. It only speaks to damages. Okay. I mean, this is really a straightforward case. How you doing, Mr. Paswell?
Doing well.
Notice at the top of page 44, okay? Punitive damages are available in an action for false imprisonment, just as they are for most of the other intentional torts, right? First full paragraph, defendant may be compelled to respond in exemplary damages. Those are punitive damages, okay? If the act causing actual damages is a wrongful act done intentionally in violation of the rights of plaintiff, okay? Exemplary damages are punitive damages, and the purpose of punitive damages is to both punish the wrongful conduct and deter others from acting wrongfully as well. I've got notes 1, 2, I've got all the notes circled on 44. The first case there, it's not false imprisonment to not allow someone in. Note 2, can there be false imprisonment in a moving automobile? Absolutely. In a city? Yes. Okay. In the state of Rhode Island? Yes, but apparently not in Taiwan. Okay. Notice in note 3 is a good one. If one exit of a room or a building is locked with plaintiff inside, but another reasonable means of exit is left open, there is no imprisonment. Okay? If y'all got mad at me and indicated that y'all were going to lock me in the room, and you blocked that door, and y'all acted like you blocked that door, okay, but you really didn't, and I didn't try to get out that door, I still haven't been falsely imprisoned. Okay? The means of escape, what's important to remember, the means of escape must be reasonable. In other words, if you did lock me in this room, I always have the option of jumping out the window, but that would be unreasonable. Okay? You don't have to crawl through glass. You don't have to walk across a rickety floor. You don't have to crawl, as the book says, crawling through a sewer is unreasonable. Okay? It's an unreasonable means of escape. Notice, and this is a favorite of bar examiners, the restatement, note 4, the restatement of torts, section 36, comment A, treats the means of escape as unreasonable if it involves exposure of the person, plaintiff in the water and defendant steals his clothes, material harm to the clothing, or danger of substantial harm to another. Okay? That's a favorite of the bar examiners. Somebody steals, somebody's in the shower after the basketball game and somebody steals their clothes, and the only way they can get their clothes back is to run through the cheerleading squad that's waiting out in the hallway. Okay? The means of escape must be apparent. That's note 5. What if it's just a joke? Doesn't matter. Notice in note 7, the restatement points out, however, that for negligence resulting in the confinement of another, a negligence action will lie, but only if some actual damage results. Right? We know, okay, so precursor to negligence, right? There are 4 elements to negligence. Duty, breach, causation, and damages. If you don't have damages, you don't have a cause of action in negligence. That's my actual damages. Negligence resulting in imprisonment of someone, however brief, will not lie unless there's actual damage. Okay? If the act is intentional, then you have false imprisonment. Okay? The intentional tort of false imprisonment. further down in the same paragraph, false imprisonment is also like battery and assault in that no actual damages need to be proved. Nominal damages may be awarded. What are nominal damages again, folks?
No.
Token damages, right? Token damages. All right, Parvey, left side. Doctor? Stand up, sir.
Okay, Parvey versus the city of Kingston, where the plaintiff was Parvey. He was trying to break up a fight between two brothers. There were three guys behind a building, and he was trying to break up the fight. The police were called. They noticed that they were all intoxicated on the influence of alcohol, but Parvey didn't have a place to go, so the police officers took him in his car and brought him to a abandoned parking lot, and that's where they left him. This was in New York in 1977, and then he wandered out onto the freeway. When he wandered out onto the freeway, he got struck by a car and sustained some injuries. He then sued the city and the police department.
Right.
For damages for false imprisonment.
Mm-hmm.
So the rule had to do with the fact that he couldn't recover because he did not know at the time of his imprisonment that he was falsely imprisoned.
That's the argument, right? So the trial court dismissed the case on a motion to dismiss on the basis that he didn't know of the confinement when it happened, right?
Right.
And notice the appellate division affirmed.
The appellate affirmed, and then he appealed to the Court of Appeals in New York.
Right. And the Court of Appeals of New York is the Supreme Court of New York.
Of New York.
Okay.
And they actually reversed the decision of the lower courts, and it was based on the fact that even though he didn't have any recollection of that particular night, that he knew at the time, and I guess there was some testimony about the fact that he didn't want to get into the police car.
Or at least he wanted to get out of the
He wanted to get out of the police car.
Right.
So he didn't want to go where they wanted him to go.
Right. But he also wanted to get out of the police car, right?
Right.
So the basis that the trial court, so the Court of Appeals said there's a big difference, right? And thank you, very good. There's a big difference in not remembering the confinement, right? He had no recollection because they were all hanged, right? He had no recollection of being in the car. That's a far cry from saying that he was unaware of his confinement when he was in the back of the car and wanted to get out. And of course, as Fran pointed out, there was testimony and evidence that he had indicated he wanted to get out of the car while he was in the back. Now, so the decision here, procedurally, okay, the reversal here does what?
Send it back.
Right, we go back to the trial court, and now since the court kicked it on a motion to dismiss initially, we'll go back and now present the evidence and see if there is actual damage. The deal is, what if the police were justified in their actions? What if they had a legal authority to put him in the back of the car? Do they have an action for false imprisonment? Is he going to prevail? No, right? No. But we'll decide those issues when we get back down to the trial court after this reversal. Yes, ma'am.
What makes the court decide whether to hear the issue itself or reverse it or remand it back? I mean, what is the line where they decide to send it back versus just making the call themselves?
Oh, well, no, see, appellate courts don't hear testimony, right? They're just deciding this issue, okay? And they'll make the decision, like it's a petition for certiorari, right, to the Alabama Supreme Court, and they want to establish this precedent that, hey, if there's consciousness of confinement, the consciousness of confinement is different from not remembering it, so this is the precedent that the trial courts will now go by. That's what the line is, okay? Notice last sentence. Okay, and we're talking about the reversal and back down to the trial court. At the very least, then, it was for the jury in the first instance to weigh credibility, the credibility of the witness, the credibility of the testimony, evaluate inconsistencies, and determine whether the burden of proof had been met. In other words, it was erroneous, it was error for the trial court to have dismissed the case on a motion to dismiss. Okay? Note 1, in addition to the false imprisonment claim, could plaintiff have filed a negligence claim based on the police officer's conduct? If he didn't prevail on the false imprisonment claim, yes. Okay, he could have filed a negligence action. Whether he would have prevailed or not is a different story. All right, so it's important. It's an intentional act confining the plaintiff against his or her will, okay? The next element is where the plaintiff is disjunctive, okay, is either aware of the confinement or harmed by it, okay? It's not the greatest example in the world, but let's think about, say a sleeping child, okay, is left in a hot car where it is harmed by, left in a hot block car. Sleeping child is unaware of the confinement, but suffers dehydration, but is harmed by being in that hot car. That's still false imprisonment, okay, even though the child is unaware of the confinement. All right? So it's where the plaintiff is either aware of the confinement or is harmed by it.
I have a question.
Yes?
So, in the instance of the child, if the child, there's a means to get out, which is the door, but the child's unable because he's strapped in, that still negates the fact that he can open the doors and get out, right?
If he couldn't get it out of the straps, yes. Okay, yes. Note 3, make sure to circle that one too. All right, right side, Hardy. You went last week. How about you, Hardy? Yes, yes, ma'am.
Hardy versus LaBelle. This is the case where Hardy was a temporary employee of LaBelle, and another employee came to the manager and told her that she saw Hardy steal a watch. Well, in the next morning on December the 10th, Hardy came in and they took her back. The manager took her back to her office to talk to Hardy. When they took her back on the pretense that she was getting a tour, but it was actually to ask her about stealing the watch. So she went back there and she spoke with them. I'm supposed to be standing up, aren't I?
Yes, please.
Okay.
But you're projecting very well. That's why I didn't say anything.
Okay. Well, she spoke to them about, they questioned her about stealing the watch. She took a lie detector test. There was some questioning about exactly who was there, how many police officers, if there were police officers and all that. And she ended up passing the lie detection test. And then they eventually let her go. The manager apologized, the store employee apologized, but then Hardy put a claim together against the store saying that it was false imprisonment. So the court came back and stated that it really was not, because she had all means to leave if she wanted to leave. She stated that she even with the fact that they did say that she was going there for one reason and that she was actually going for another reason, she did state that even if she had been told the truth, she would have still followed them.
That's right.
And went. So they found that it wasn't an issue because she could have lived.
All right, so what is your issue statement for this case?
Whether false, let me go back. The issue statement would be whether a person.
It's a tough one, right? It's a tough one, right?
Well,
Because what do you think is the point here?
Well, see, I'm getting, because we discussed this a little bit, Laurie, fundamentals, and that's why I'm kind of getting a little bit, because one of the things that I was seeing when we discussed it earlier, it was the case of if she felt that leaving would have jeopardized her job or something else.
Right.
So then, because of the intent of it, was it false imprisonment?
Well, okay, so the real question here is whether the deception to get her into the room satisfies the intent element of confining her against her will, right?
Oh,
And the
okay.
answer is no, right? Okay, and
Yeah,
it's also, you also hit upon the other things, right? Did she ask to leave? Was she told she couldn't leave?
Yeah, no, she wasn't.
No.
She couldn't leave, and she didn't ask to leave.
And she didn't ask to leave. That's two. That's the second thing. The third thing is the duress issue, right? Whether she thought if she left, she was going to lose her job. And in the notes, we tell them that's not enough, right? It's if she loses her job because she wanted to leave, what is her redress there?
Then it would be false imprisonment.
No, no. If she leaves and they fire her, what does she do? Wrongful termination, right? You have redress. You seek redress in the courts, right? That's why the loss of a job is not sufficient. Okay. Now, harm to oneself, or harm to a loved one, or harm even probably to a pet, right? That qualifies. Okay, but not the loss of a job.
Question.
Yes.
So how many issues do we have? Because it seems
It's
like
primarily
there's a lot.
that's the big one, right? The big one is.
Because I'm kind of confused with this
Because I
issue
didn't
right
even
here. I don't
catch
know
that.
how many do I actually have, or
Well, I mean, I think probably what you have there is what, is enough. What do you have? What's yours?
Mine's, I don't think mine's is right. Whether the evidence is significant to support the verdict in the judgment, and whether the district court error in the insertion of an instruction.
Well, I mean, I know that Barbara talks about, that's a little broad, right? We want to get down into why is this case about false imprisonment, right? Okay. Yes?
Would putting a defendant not be held liable for false imprisonment when there is no threat or force used to compel someone to stay?
Sure, that's better, right? That's better. There's no threat and also no request to leave, right? So you can combine those. That's pretty good, right? Notice in the fourth full paragraph on 48, the two key elements of false imprisonment are the restraint of an individual against his will and the unlawfulness of such restraint. The individual may be restrained by acts or merely by words which he fears to disregard. Okay? Notice in note 1, the restatement suggests that in addition to physical barriers, a false imprisonment can be accomplished by force, threat of force, duress, or asserted legal authority. Second sentence, that's what I was getting at with this case. If the plaintiff submits, the second sentence, note 2, if the plaintiff submits merely to persuasion and accompanies the defendant to clear himself of suspicion without any implied threat of force, the action does not lie. Note 3, retention of plaintiff's property sometimes may provide the restraint necessary. And when you see this, and when you hang on just a second, and when you see this in sample questions, what you'll see is the retention of something valuable like a fur coat or a watch, an heirloom. Some of those Coach bags that are so expensive. Yeah.
So did this all rest on her not feeling like she had to stay? Is that what should be the case? Or even if she felt like she had to stay, that still would be?
Well, they didn't threaten her. The absence of any threat at all, okay, even the absence of the threat of even losing the job, that's what the key is, right? She could have gotten up. First of all, she could refuse to go to begin with. Secondly, she could have gotten up and walked away. They didn't say, they never even implied, the defendant never even implied that she was going to so much as lose her job, and she said, I'm out of here. right? So there's no, she wasn't compelled to stay against her will at all. Okay?
So what she felt didn't matter at all. I guess is that the answer?
No, I mean, if she had wanted to leave and they said no, yes, right? But the fact that she never even said, hey, I want to get out of here. No, you have to stay, right? Yes.
Is it objective or subjective?
It's subjective, right? It's subjective. What was going through the mind of the plaintiff at the time? Just like the guy in the car, right? Just like Harvey. Right. It's not. Note 4 is about the job. Fear of losing one's job is a powerful incentive, but it does not render behavior involuntary. Note 5, it is generally agreed that false imprisonment resembles assault and that threats of future action are not enough. Thus, the action does not lie where the defendant merely threatens to call the police and have the plaintiff arrested unless he remains. Okay, and we will see when we get to privileges on the 15th, we will see there is something called the shopkeeper's privilege, where if someone, if an individual is suspected of having shoplifted something, then the shopkeeper has a privilege to detain that person for a reasonable period, in a reasonable manner, for a reasonable period of time, in order to conduct an investigation. And we'll talk about that in a couple of minutes. Sorry? For a reasonable period of time, right? It's got to be a reasonable approach for a reasonable period of time. No, I don't think this whether this lady was unreasonable. I mean, it's different here because but that's a reasonable for her. No, they did keep her. I mean, they won, right?
Right.
The defendant was not lying.
Right.
Oh, yeah, well, no, I mean, to me, the detention of this employee to determine whether she took the watch, that's reasonable, right? I don't think there's anything wrong with what they did. Myself.
But
Yes?
the fact that they were a little bit deceitful, they said, we're going to give you a tour of the store. Then they get her into the back, and then they kind of confine her somewhat, and she doesn't even know what's going on. So I thought that was a little bit...
Well, I mean, sure, they could have been more upfront with her, maybe, but they don't know. The fact that she says after the fact, well, if they had just told me what this was about, I'd have gone with them anyway.
Right.
That's just sort of hindsight's 20/20, right?
Yeah.
They don't know that she's going to react to it that way, right?
Do they not have cameras open?
No.
Okay, which side are we on? Enright.
It's on this side, but can we do it?
How are you? Enright.
This case, after the Colorado Court of Appeals, 1977, between the plaintiff.
A little louder, please.
The plaintiff, there was the actual defendant, the police officer, was on duty and saw a dog in violation of the city's leash ordinance. He saw the dog approaching the house. The plaintiff, name was Miss Enright. Defendant, the officer, encountered the plaintiff's son at the door, asked if the dog was his, and he said it was. The mother, who was sitting down the street, the officer ordered the boy to pick the dog up. The defendant testified that he met Mrs. Enright, the plaintiff, and asked if she could help him. The officer then asked him to see her driver's license. The plaintiff replied, giving the name and address, but refused to give the driver's license up to the
Right.
officer. Then the officer,
A little louder.
the officer advised her to give up her driver's license or she would go to jail. So the plaintiff replied, "Isn't this ridiculous?" Then the defendant grabbed her arm and said, "Let's go." Then she was arrested and taken to jail in violation of the dog leash law. One of the issues is the plaintiff's claim for false imprisonment or false arrest over the holding. I know in the ruling, it looks like this false arrest may arise when one is taken into custody by a person who claims she does not have proper legal authority.
Right. There you go.
Then analyzed it, possibly the reasoning in the holding. Claiming she was arrested for violation of the city's leash law ordinance. Not the fact that she did not produce her driver's license, but the whole premise and founding basis for her arrest was that she did not produce a driver's license to the defendant or the officer. The court found there was no statute or law in the jurisdiction which requires her to show a driver's license upon demand unless it possibly an operational function of the car. Wrapping it up, the defendant demanded the plaintiff's driver's license. It wasn't a lawful order.
That's right.
And basically, refusing to comply was not an offense according to the court. The court ended up affirming the judgment in favor of the plaintiff.
Okay, good. Good. That's good. We got it. So, police officer had no legal authority to arrest her. And first of all, had no legal authority to arrest her for violation of the leash ordinance, because that is just a violation of the ordinance, and it's not a jailable offense, right? It's a fine. 2, there was no law saying that she had to produce her driver's license upon demand, and therefore the police officer was also he also exceeded his authority to take her to jail for that. Okay, I've read this case 100 times, and I'm still trying to figure out why the kid was in the house and the woman was in the car. Okay. They had just gotten back. Is that what it says?
Yeah, they had just gotten back.
Oh, okay.
Parked the car. Dog ran out.
Oh, okay. All right. Well, then my joke fails. Sorry.
I'm sorry.
No, that's all right. So, absent legal authority, I mean, here the police officer exceeded his authority, and therefore false imprisonment line. Notice in the last sentence. Thus, Groves, the police officer's defense based upon an arrest for and conviction of a specific offense must, as a matter of law, fail. Okay, as a matter of law, this defense will not work. We will get to privileges with regard to making citizens arrest and other such things. There are about 6 different rules, and we will talk about those on the 15th. But it is not necessary that the defendant be an officer to assert authority of law. Okay, and this goes back to the shopkeeper's privilege. Note 2, a private citizen who physically aids a police officer in making a false arrest can be held liable to plaintiff for false imprisonment. All right, the seminal case, Whitaker v. Sanford. Go ahead.
Okay, in this case, the plaintiff and her husband were members of this religious group that were going to spend it. And so the plaintiff wanted to go back to America with her husband and her 4 children. But the defendant, when she was about to board this boat, the defendant came up to her and was like, "Hey, you don't want God, and I'll take you back to America." And she told him that she would be scared, that he wouldn't let her go, and try to convince her that he was on the movement. So he was like, "No, I'm not going to do that by any means. I'm not going to make you join these American lives." So she got on the yacht with him, and her family did. And when they got where they were going, the defendant basically told her that it was up to her husband to let her get on the boat that she needed to get back to the shore. Well, her husband was like, "No, it's up to the leader." So she ended up stuck on this boat for like a month until she received she ended up suing for false imprisonment. So the issue that I found was that even if there's no physical restraints present.
Say that again, say it again, say it again.
Okay. So, hold on.
No, I just didn't hear you.
Okay, so I said that the issue was even if no physical restraint is present, can confinement of an individual to a bound area solely result in false imprisonment?
Sure, okay. I kind of live with that.
Was I supposed to say how little law before that?
No.
Okay. Well, the answer, which I said was my holding, was yes.
Yes.
Confinement was due to the defendant being charged with both. And so he didn't let her go when he had being in charge of letting her go. And of course he said he would, and then he ended up not letting her go. So, yeah, the court ended up ruling in the plaintiff's favor.
What year are we in again?
1912.
Yeah, right. So why are we not convinced that she had a reasonable means of escape because of the boat?
I mean, agree on that because she needed a boat to get out of the shore. So either she could be stuck.
Are you saying that a lady can't get out of a boat?
I mean, yeah.
Can't row a boat?
She would have to swim, and that would have put. She had 4 children with her that she was in charge of.
No.
So it just would have been. I mean, it's
That's not a reasonable.
No, it's not possible. She could not have swam.
But they didn't say he refused to let her use the boat. That was what made it.
Wait a minute, hang on. I thought that she could have, well, the point, she could have snuck out
No,
on the
he
boat.
Okay.
I'm joking with you. Notice, hang on, yes?
Yeah, it says he refused her, but I was wondering about where the kids factored into this, because they didn't really seem to mention them very much in the book. I mean,
Right.
4 kids.
Well, she's not suing on behalf of the kids, it's about her, right? She's suing for false imprisonment. But sure, I'm sure the children figured into it.
No, but I mean, like, could she have based this on the fact that she had 4 kids on that boat?
Yeah, I mean, she didn't need to, right? I mean, that's the point is she didn't have to. She was, look at the language. Hang on. Look at the language. Yes.
Well, they couldn't really base it on the kids because the father was on the boat too.
Mhm.
So she didn't have a judgment for
custody
or anything.
Right.
I didn't realize it was on both.
That,
Yeah, because he's the one.
reading too much into it. Reading too much into it.
That's irrelevant. The sea around the water around the boat.
Yes.
Is it irrelevant that she was allowed to leave the yacht?
Only with him.
Only,
But she was a convent. I mean, she had someone that could.
right. She had a custodian, right? She had a, yeah.
That's still
That's,
in prison.
that's, you know, in 1912, that's relevant, right? She could not get away to tell somebody. It was a long time ago. You see what I mean? The chaperone changes the whole complexion of that. Even though she did go ashore one time, she ended up, I mean, however many times she went ashore with that chaperone, she finally had to hunt down a sheriff and say, I want to get away from this guy, right? It was a different world back then. I'm pretty sure of it. You might think I was around then, but I'm not quite that old. But the main point, okay, all of this aside, all of those are good questions. Notice at the bottom of the big paragraph on 52 in the middle of the page, the boat is the key. By refusing the boat, he turns the key and locks the door. The guest is effectually locked up as if there were walls along the sides of the vessel. The restraint is physical. The impassable sea is the physical barrier. Okay? So this counts, right? This works. There was no practical way for her to go ashore except in the yacht's boats. Note 1, the answer to that question is yes. I've got note 4 circled as well. Score report. Sleep on the job back there. Are they? That's the only one that matters right now, right? Everything else blew up. Oh, okay.
You say Texas is coming up?
Oh, this a bird.
49 for Atlantic 0, TCU 41 over Southern University. Clemson 27, Harvard 0.
Well done, thank you.
Closed doors off Oregon State 32-14. And Harvard with Maryland, Texas 24-22.
24-22 at halftime. All right, good. So, y'all read Seliznov for LFC, right?
What we like,
What's the main point in Seliznov?
severe, outrageous behavior. Yeah.
The mental distress must be severe, right? And generally, we can have symptoms, right? Physical symptoms, although it's not necessary. It helps if they're to show that the mental distress is actually severe. If we have physical symptoms, vomiting, sleeplessness, heart attack, right? Things like that help. Symptoms like that help, but the point is that the emotional distress must be severe. Any questions about Seliznov? Yes.
Just in general, I mean, I realize that it has to be severe, but is there a differentiation between the manifestation? Does the manifestation have to be severe, or is there any way to prove it?
No. I mean, but it just helps that you have some sort of physical symptom. Okay? The language in note 3 on page 56 is the language that you need to use, right? Kentucky has referred to this tort as a gap filler. Clearly, the conduct in question must be extreme or outrageous and intolerable. It must violate generally accepted standards of decency and morality. Okay? Beyond the bounds of civilized society. Okay? The conduct, extreme and outrageous, of such a nature that it is beyond the bounds of civilized society. Notice at the end of that note, and while the intentional infliction of emotional distress could be pleaded alternatively, a litigant cannot prevail on both a negligence claim and an intentional infliction of emotional distress claim on the same set of facts. Does that make sense to y'all?
Yes.
Do you understand why that is? It's one or the other. It's either intentional or it's negligent or accidental in that a duty has been breached, but not necessarily intentionally. Okay? Note 5 is also this is also a favor to the bar examiners. Interference with the body, the corpse, a dead body, generally is automatically of a family member. Is generally conclusively intentional infliction of emotional distress. It's presumed that that the interference with the body of a family member will cause sufficient emotional distress. Okay. Note 6, common carriers and innkeepers have been held to a higher standard of conduct and sometimes held liable for using insulting language to their passengers and patrons. The tort of outrage, okay, is the same as IIED. That's in note 7. So what about Slocum? Go ahead.
Slocum, plaintiff.
Stand up,
I'm sorry.
please.
Okay,
Project.
Supreme Court of Florida, 1958, procedural history. Plaintiff sought monetary damages for mental suffering of emotional distress caused by a defendant's employee. Questioned of the assertion of a deliberate disturbance of emotional, and I cannot pronounce that word, in equanimity, state and independent cause of action in tort.
Equanimity?
Yeah, equanimity. All right. Thank you. Tongue tied. So what we had was the plaintiff went to the store, asked the employee about the price, and he said, if you want to know the price, you have to find it yourself. You stink to me.
You stink.
Yeah. His language, though malicious and grossly reckless, was not suggestive of outrageous and extreme conduct. Maybe in that day it was. Whether the defendant's argument is that this was hurtful. She claimed that there were actual injuries because she had a heart condition and other things that she felt that caused him to be liable. The rule is there's liability only for conduct exceeding all bounds which could be tolerated by society of a nature, especially calculated to cause mental damage or of a very serious kind. And so it did not rise to the level of outrageous, extreme, and beyond what is allowable in nature.
Right. And so the court also says we're all in this together, and sometimes we just got to be a little tougher than we want to, right? You got water off the duck's back kind of thing, right? So the language you're looking for here, at the bottom of the page, when the act is done for the purpose of causing the distress or with knowledge that severe emotional stress is substantially certain to be produced by such conduct. Notice that's specific and general intent, right? And then in the middle of the next paragraph, so far as it is possible to generalize from the cases, the rule which seems to be emerging is that there is liability only for conduct exceeding all bounds which could be tolerated by society, of a nature especially calculated to cause mental damage of a very serious kind. This does not rise to that level. Okay? Notice in the middle of the next paragraph, the unwarranted intrusion must be calculated to cause, quote, severe emotional distress to a person of ordinary sensibilities. That's objective, right? That is objective. A person of ordinary sensibilities.
That's objective.
Yes, that is objective. In the absence of special knowledge or notice, there is no inclination to include all instances of mere vulgarities obviously intended as meaningless abusive expressions. Why is this not a tort? Why is the insult not a tort in and of itself? Question 1 on page 60. I'm sorry? No, I mean, it's flood of litigation, right? We'd open the door to everybody be suing everybody. If I had the opportunity to sue everybody that ever called me an asshole. Okay? See what I mean?
Yeah.
There has to be a line, otherwise, a higher bar. Otherwise, people will be suing each other all the time. Quote in note 2, against a large part of the frictions and irritations and clashing of temperaments incident to participation in a community life, a certain toughening of the mental hide is a better protection than the law could ever be.
All right. Mental hide.
No pressing social need requires that every abusive outburst be converted into a tort, Upon the contrary, it would be unfortunate if the law closed all the safety valves through which irascible tempers might legally blow off steam. Notice in Note 3, none of the language in Note 3 was found actionable. I've got Note 4 circled as well. And in Note 5, it discusses the Phelps case where those crazy people used all of the abusive language at the funeral of the veteran, and the Supreme Court had to weigh in. And as much as that behavior, which I despised it, I thought that I agreed with the court once the opinion was issued. Without discussing Jones at length, what is the point of Jones? Harris v. Jones. What's that, Ms. Kafka? Right. There's a line, and this, even though this might be reprehensible, A, it didn't get to the line, right? And B, the exacerbation of his stutter is not enough of a physical manifestation to prove the existence of severe emotional distress. Okay? Other than that, that's why this case is here. Notice section 46 on 62 from the restatement. And that repeats the one who by extreme and outrageous conduct intentionally or recklessly, notice that's in there, right? You talked about that with Barbary. It's disjunctive. You can have a reckless infliction of emotional distress, okay? And we're also going to talk about negligent infliction of emotional distress, but that's down the line, okay? The elements at the top of 63, if you didn't highlight that and make a note card, you should, okay? Notice in the fourth full paragraph on 63, it is for the court to determine, first, whether the defendant's conduct may reasonably be regarded as extreme and outrageous. Where reasonable men may differ, it is for the jury to determine whether, in the particular case, the conduct has been sufficiently extreme and outrageous to result in liability. Okay? If the court looks at the circumstances of the case, the allegations in the pleadings, okay, in the complaint, and looks at it and says, you know, this, for instance, with Slocum, okay, the court could have looked at that and say, this doesn't arise to the level that legally would ever result in liability, so what happens? The judge in that case dismisses the case as a matter of law. If the judge finds that the behavior could, by a reasonable person, be regarded as sufficiently extreme and outrageous, then what happens? We produce testimony, we present our case, and the jury decides whether in that particular case, based on those facts, liability results for the defendant. Okay, we understand. You understand where I'm going here, right? Excuse me. Notice at the bottom of the page, the fourth element of the tort, that the emotional distress must be severe, was not established by legally sufficient evidence justifying submission of the case to the jury. All right, so the judge here has dismissed this as a matter of law, because the fourth element was missing. That element of the tort requires the plaintiff to show that he suffered a severely disabling emotional response to the defendant's conduct. The severity of the emotional distress is not only relevant to the amount of recovery, but is a necessary element to any recovery at all. Okay? In note 1, there's that language again, conduct exceeding all bounds usually tolerated by decent society. Use it. Notes 2 and 3 on 65 are fair. But not. Note at the top of 66, Grantham v. Vanderzeel, Alabama, 2001. The court found as a matter of law that the mere fear of contracting a disease without actual exposure to it cannot be sufficient to cause the level of distress necessary for the tort of outrage. Notice the tort of outrage is a real thing in the state of Alabama. We don't call it IIED.
We call it outrage. But
We call it outrage.
They're the same.
Yes, same thing. Where you see IIED a lot in multiple choice questions, okay, is with bill collectors, okay? The conduct of bill collectors in trying to collect money or repo men, okay? You'll often see that they go over the line and can be held liable for IIED/outrage. Okay, so that note about collection agencies is a good one. Evicting landlords, note 5F on 67, yes. And then that next paragraph, does this statement capture the common theme? Whether an actor's conduct is extreme and outrageous depends on the facts of each case, including 1, the relationship of the parties, 2, whether the actor abused a position of authority over the other person, 3, whether the other person was especially vulnerable and the actor knew of the vulnerability, 4, the motivation of the actor, and 5, whether the conduct was repeated or prolonged. That's a nice little tight list right there. Yes, sir.
So I made a note when I read that seems to be contradictory to Harris, the preceding case that we read, because he was the supervisor of the employee. He knew about his stuttering problem. It was prolonged for 5 months. Kind of seemed like that was a bullet point almost of the previous case.
Yeah, but what was the problem with the case?
Just because that it wasn't severe.
It wasn't. His response wasn't sufficiently severe, right? We weren't. The point was not. Yes, was it extreme and outrageous? The activity of the boss in picking on him for such a prolonged period of time. Yes. The bottom line is the fourth element wasn't met, and therefore that's that case. So right. So it's not contrary to this. Okay. Yes.
I know he didn't meet the element, so what cost did that element have to pay?
I'm sorry, where?
At the bottom of the end of the story, it said the judgment firm was also paid by the element. What cost did he have to pay?
Oh, court costs. Court costs. Now, and in some cases now, that's a good question. In some cases, especially when we have statutory liability, okay, you have a fee shifting provision where the loser not only has to pay the court costs, but has to pay the attorney fee for the other side. That's not the case there. Note 6. Note 7, vulnerability of plaintiff. Plaintiff sensitivities may be a factor in deeming defendant's conduct extreme and outrageous. That's part of that list, right? Especially if the defendant knows of the plaintiff's sensibilities and is picking on them specifically. Okay. Notice in the last parenthetical in the first note, in note 7, In upholding jury verdict for plaintiff, court notes it appropriate to take into account defendant's knowledge of plaintiff's vulnerability to emotional distress based on her attachment to the horses. Okay, you'll see that a lot. You'll see that in questions too. You know, pets, somebody killing a neighbor's barking dog, right? You'll see that in Note H, should special protection be afforded to pregnant women? I don't love Note 9 because should protection also be given to the hypersensitive or idiosyncratic plaintiff? The answer to that is sometimes, okay? And so it's not a really easily tested subject, so don't look for that, okay? Because I say sometimes yes and sometimes no, right? If somebody is really hypersensitive, then the answer is no. I mean, this particular example is anomalous, I believe. Note 10 is very important. All jurisdictions require that the plaintiff prove severe, not just mere emotional distress. This is frequently characterized as distress so severe that no reasonable person could be expected to endure it. Note that unlike most torts, the severity of the damage affects not just how much the plaintiff will recover, but whether the plaintiff recovers at all. Note that testimony that the plaintiff was upset and cried will not be enough. Again, we've got to have severe emotional distress. Generally, it helps if you have physical manifestation. Although it's not necessary. Last sentence there. Most, however, do not generally require expert proof to establish severe emotional distress caused by defendant's conduct, preferring to rely on such factors as the flagrant and serious nature of the defendant's conduct, subjective testimony from plaintiff and others, and physical symptoms. Did y'all read Taylor v. Vallelunga for LFC? Okay. What's the point of Vallelunga? Yes, ma'am. Okay, all right. So say the rule again for me. Right. The whole point is You can't intend, say it. You can't intend to cause emotional distress if you don't know someone is there, right? You can't intend, we're talking about, the point is absolutely that. This is an intentional tort, so you have to either specifically intend to cause emotional harm to a person, or you have to act with substantial certainty that this harm is going to occur, right? If you don't know they're there, you can't possibly have those two, either one of those things. Okay? So, watch for that scenario, right? It's another favorite intentional tort backpack. Okay? Bouncers, beat up a man, and they don't know his girlfriend's right around the corner watching the whole thing happen. She sues, she loses. Okay? That's a favorite. I think there's one on the midterm. Okay? So, watch for it. Two bouncers beat up a boyfriend outside a club, okay? And they don't know that the girlfriend is nearby, and she sues and she'll lose, right? Because they can't intend to cause her harm if they don't know she's there. Yes. IIED doesn't count.
Nope.
I thought it had to be a relative.
Yeah, because then but then you've got, they still have to know that they're there. Like I can, as you see in the notes, okay, if you were to harm my lady in order to intend to harm me, okay, now that counts. I don't have to see that happen because your intent was to harm me whether I'm there or not, okay? But that's sometimes that might be hard to prove, right? Okay? Notice on 70. A is sitting on her front porch watching her husband B, who is standing on the sidewalk. C, who hates B and is friendly to A, whose presence is known to him, stabs B, killing him. C is liable to A for the mental anguish, grief, and horror he causes. Okay? The other thing to remember here, folks, is that it's contemporaneous perception of the act, right? It does not have to be, you don't have to see it, you can hear it. Okay? If a child is in the house and the defendants know that the child is in the house and the child can hear the beating, that's enough. Okay? It's not necessarily limited to seeing it firsthand.
But you got to know that they're present.
But the defendants have got to know that the child's in the house. Okay? If they showed up and they knew that the child ran to the back of the house, they're not going to be able to claim that the child wasn't present because they knew it. Okay? Note 1, generally committing a murder or a suicide is not a tort against an eyewitness. However, it may be if the act is directed at the plaintiff or if the defendant knew that extreme emotional distress was substantially certain to follow. There you go, Ms. Kafka. 2, as California did in the principal case, many jurisdictions continue to require that the conduct not only be intentional and outrageous, but also directed at the plaintiff or take place in the presence of the plaintiff with the defendant's awareness. Notice contrary authority at the bottom there, but see Doe v. Roman Catholic Diocese of Nashville. Conduct need not be directed at a specific person or occur in the presence of the plaintiff. I think we know what was going on there. Okay? Some, parents were allowed to recover in that instance, my guess, without even having looked it up.
I have a stupid question.
Okay.
Never mind, I'm not gonna ask
I say that a lot, right? I'm really joking, but despite what your elementary school teacher tells you, there are such things as stupid questions. There is in note 4, sensory and contemporaneous observance of defendant's acts does not necessarily require being able to see what is happening. And then we have some narrow exceptions in note 5. Okay. Trespass. Trespass is an intentional physical invasion of another's real property. An intentional physical invasion. The distinction here is with nuisance, okay? So we're talking about a physical thing, not necessarily a person, must intentionally invade another's property, okay? It can be the basketball that goes over the fence, okay? Mistake doesn't count if, however, it must be intentional. If Gus Malzahn, right, intends to step into Coach Saban's land, even honestly believing it to be his own, he has committed a trespass because he intended to take the step. Okay? However, if overzealous Auburn fans carry Gus Malzahn onto Coach Saban's land, then they have committed a trespass, not Gus Malzahn. Okay?
That's exactly it.
Okay? Notice in Doherty, okay, the last couple of sentences, or the last sentence, but it is an elementary principle that every unauthorized and therefore unlawful entry into the clothes of another is a trespass. From every such entry against the will of the possessor, the law infers some damage, if nothing more, the treading down the grass or herbage, as here the shrubbery.
Get me a shrubbery.
That's the last sentence in Doherty v. Step on 72.
Thank you.
Okay, the law infers some damage. And what, in this instance, what do we get when we just infer a little damage and we've got a trampled shrubbery? Nominal damages. We're learning, man. I got you, see? Notice in note 2. Well, note 1. One of these is, here we're concerned only with intentional trespass. There may be negligent entry, but it is governed by the ordinary rules applicable to negligence, and therefore we have to have damages. Okay? 2. Notice that the right to sue for trespass belongs to the tenant, the party with the right of possession. So the tenant has the action, not the landowner. Okay, as long as the tenant is is possessing the land. Okay? Note 3 is my Malzahn example. Note 4 discusses nominal damages. Note 5, when a trespassory invasion is found, the fact that defendant's conduct was socially useful or even beneficial to plaintiff does not affect liability. It only speaks to damages. There is a distinction between an action in trespass and an action for ejectment. Trespass is temporary. Ejectment is if the defendant has taken up residence or won't leave, as an action in ejectment. So, the again, physical invasion. So when we talk about nuisance, we talk about a non-physical invasion of the use and interference, an unreasonable interference with the use and enjoyment of a plaintiff's land. Okay? In the nuisance context, I think I mentioned this last week, what we're talking about, light, noise, dust, vibration. Okay, now that's what we're talking about, a non-physical interference with the use and enjoyment of a plaintiff's property unreasonably. Heron v. Sutherland merely stands for the proposition that it extends up to a reasonable, the exclusive possession of the plaintiff extends up to the sky for a reasonable height and below the ground for a reasonable depth. Okay? Bottom of 74, in its legal significance, has an indefinite extent upwards as well as downwards. Whoever owns the land possesses all the space upwards to an indefinite extent, such as the maximum of the law. However, in the next paragraph, 75, however, it seems to be the consensus of the holdings of the courts in this country that the airspace, or at least near the ground, is almost as inviolable as the soil itself. It always comes up, right? We talk about airspace, we talk about airplanes flying overhead, right? Okay, but I don't want to get, that is an absolute rabbit hole that we're not going to, all I have to say is that I think the proper action in that case, in those cases where you have constant flights overhead neighborhoods, right? I think that action is well, it's iffy, but I think it's really more of a nuisance than it is a trespass, unless you're really, really close to the airport. Okay, but again, it does figure the taking clause, as the note tells us on in note 6, when government overflights have substantially affected habitability of the land below, a court may find a taking within the meaning of the Fifth Amendment, and so the government would have to compensate the landowner for the land. No, yes.
What about in the case of drones? I mean, now that's becoming more and more common, and people.
Now listen, I think if my neighbor flies a drone over my house and it's, call it 100 feet in the air, that's trespass, right? It's an action trespass, and I think you could, and it's also, you can win both a trespass and a nuisance. It's both, to me, that's both a trespass and a nuisance, right? Because that drone is close enough to the ground. I could get nominal damages for trespass and then probably get an injunction for the nuisance. Yes?
So Huntsville, you have Redstone Arsenal, Constant, and you have NASA. But I'm arguing about the missile stuff. I mean, they're testing missiles like if they would in White Sands to protect us. I mean, they're protecting the country, right?
Right.
That's what they're doing. So nuisance.
Potentially, but the societal benefit of that activity is going to figure in to that analysis, and we will see that when we get to nuisance, right?
It shakes everything on the wall.
Right. It is a nuisance, but the social utility of that outweighs the inconvenience.
What are you calling it?
The social utility, right? The societal benefit of testing surface-to-air missiles outweighs the nuisance that is the vibration that occurs to the walls of the house. Okay. Rogers v. Board of Road Commissioners for Kent County. Okay. The reason this case is here is because it is a continued trespass, right? The stake that was left in the field that caused the eventual death of the plaintiff's decedent, okay, was an action in trespass. Notice why didn't we sue for negligence? Because it was easier, it was easier to prove that it was a trespass, right? Because then we're going to get into an argument of whether how great of a breach of the duty of care was it to leave this stake where it was. Okay, this is obviously a trespass because the permission granted, okay, first of all, the use of the stake had passed, right?
Yes.
Two, the permission to be on the property had also expired, okay? So we obviously had an intentional physical invasion of another's real property. Yes, sir. You with me? Oh, okay. I thought you
Just
were
counting you.
Oh, okay. Okay, so this is about a continued, the reason this case is here is to introduce to you the concept of a continued trespass. Note 2, right, there's what I'm getting at. A privileged entry onto the land of another, okay, may be limited not only by time and space, but also by purpose. Note 3 is about, note that in the principal case, the defendant is held liable to the plaintiff for the death of her husband resulting from the trespass without any question of negligence in failing to remove the anchor post. That's because it obviously was an intentional physical invasion, right? We didn't need to argue about the breach of duty or negligence. Yes?
Why wouldn't they have tried both negligence and the trespass? Why wouldn't they did both?
Well, they probably pleaded it both. The court just didn't have to discuss it, right? They probably did plead it both. As a plaintiff's attorney, you would plead both. Absolutely. Okay. You might not. You wouldn't be able to recover for both, but you would certainly plead both, right? Circle note B or 3B at the top of 79. Note 3C, just the last sentence. I mean, something to remember. Court held that damages, heart attack caused by a trespasser need not be foreseeable to be compensable. And keep note 4 in mind as well. Okay. Trespass to chattels. I'm going to tell y'all everything if y'all will just listen to me for the next 10 minutes, I'm going to tell y'all everything you need to know about trespass to chattels and conversion. Okay? Trespass to chattels is the intentional interference or intermeddling, you can use either word, okay, with the personal property of another such that damages occur. Okay? The thing to remember about trespass to chattels is you have to have damages. My offense at your leaning against my shiny, clean car is not enough. There has to be some physical damage to the car.
Can you repeat the rule again?
If the interference is for a short duration and no damage occurs, right? Then the defendant is liable for the lack of availability of the personal property. Okay? For instance, if I loan my car to a friend, right, and he says he's going to return the car on Tuesday morning, and he does not get back until Wednesday with my car, and for whatever reason I missed an appointment or it cost me money, he owes me the rental value of that car for a day plus the consequential damages of my having missed the appointment and not having made a sale. Okay? Don't forget that trespass to chattels, transferred intent Also applies to trespass to chattel. What is the point in Glidden? Why is it there? Because what are they trying to do there? I like this little case. They were trying to say that the girl, right, the dog is a chattel, right? And if the girl was in the act of committing a trespass to chattel, then they wouldn't have to pay for her injury, right? And the point is that there was no damage to the dog, therefore she couldn't have possibly committed a trespass to chattel, and therefore they were still liable, okay? Look at the middle of 80. One who, without consensual or other privilege to do so, uses or otherwise intentionally intermeddles with a chattel which is in possession of another is liable for a trespass to such person if the chattel is impaired as to its condition, quality, or value, or B, the possessor is deprived of the use of the chattel for a substantial time, or C, bodily harm is thereby caused to the possessor or harm is caused to some person or thing in which the possessor has a legally protected interest. Notice further down, is not given legal protection by an action for nominal damages for harmless intermeddlings with the chattel. Nominal damages are not available in an action for trespass to chattel. Don't let me fool you. I'll fool you. Now, what is the next case? CompuServe. Is that the next case? Yeah. CompuServe.
Can you really quickly just say the intentional interference with personal property? Can you say that again one more time?
Sure. Trespass to chattel is the intentional interference or intermeddling with the personal property of another. Okay. And then you can, such that damage to the chattel occur, or the plaintiff is deprived of the use of the chattel for a substantial period of time. Okay?
So no nominal damages in.
No. You have to have actual damages in trespass to chattel. Note 3, trespass to chattels is now quite universally limited to intentional interferences. Note 4, I'm on 81. As in the case of trespass to land, the conduct is treated as intentional even though the defendant acts under an innocent mistake. And note 5, what I'm trying to hammer home, unlike trespass to land, trespass to chattels will not lie unless there is an actual dispossession of or actual damage to the chattel itself or to its owner or his property. Cyber promotion, the CompuServe is here because Cyber Promotions interfered to such an extent with CompuServe servers that they were deprived of effectual use of them, therefore the action in trespass to chattel will lie, okay? On 83, down at the bottom, electronic signals generated and sent by computer have been held to be sufficiently physically tangible to support a trespass cause of action. Remember that difference between trespass and nuisance I was just talking about? Yes, ma'am.
Can the actual lawsuit be held as the damages, like for the owners of the dog, they're responsible for there wasn't damage to the dog, but they did incur damages from the actual lawsuit that they had to pay back?
No, I see where you're going, but no.
In CompuServe, here they're just giving them an injunction. They're not getting damages. So how does that play into this?
Where are you? What part are you looking for? I don't love this case, so let me be real on it. I kind of picked out the good parts that I remembered and just moved on. But go ahead.
My question is, why is there no damages here? It's just an injunction. is stopping them from meddling.
Well, all right, here's the thing about damages, right? And that's a good question, right? Where does it,
At the
That's
end.
all they were seeking.
that's all they were seeking, they just wanted them to stop, right? The problem with damages is you gotta be able to calculate them, right? And so if that would have prolonged all of this indefinitely, if all of a sudden CompuServe had said, okay, well, you know, you interfere with our business, okay? All right, so we interfere with your business. How much money did that cost you? Well, I don't know. You know, is it 1 million? Is it 25 million? Is it? But you got to be able to calculate it, and you got to have experts and all that. Here, they just wanted them stop doing this, go away, don't do this anymore, and that was enough of a victory for CompuServe in this instance, right? Yes, ma'am.
But they did put in there temporary restraining order extended until final judgment. So I assume something else is going on.
It could very well be. Plaintiff's motion for a preliminary injunction is granted. The temporary restraining order filed on by this court is hereby extended in duration of filed. Yes, it could very well be. This was just part of it. That's the answer. See, I skipped right over it. I told you. Note 2 on 85. Note 3, no. Okay. Conversion is just the big brother of trespass to chattel. Okay? It is an interference or an intermeddling with the personal property of another, such that the defendant, or let's play it the other way, the plaintiff is justified in recovering the full value of the chattel from the defendant. It is a forced sale. It constitutes the interference is such that it constitutes a forced sale of the chattel to the defendant, where the value is calculated, its fair market value at the time and place of conversion. Say it with me. Fair market value at the time and place of conversion. It is not replacement value, however, okay? In other words, if you borrow the lawnmower and the lawnmower gets destroyed, okay, the defendant is liable for the full market value of that lawnmower as it existed when it was destroyed. It's not the value of a new lawnmower, it's the value that you could have gotten on the open market for that lawnmower, however old it was when it was destroyed. Yes, sir.
Is this similar to like car accidents where they give you like a fair market value on the amount of the car? Is this kind of a similar?
Yes, that's exactly what it is, right? It's a forced sale of the. I mean, we can talk about cars, right? If I loaned you the car and you wrecked the car, you owe me. That's a conversion, first of all, and you owe me for the fair market value of that car as it was when I loaned it to you, or as it was when you wrecked it. Okay.
Garrett.
Yes.
Can you restate the definition of conversion?
Sure. It's a interference, an intentional interference or intermeddling with the personal property of another, such that the plaintiff would be justified in collecting the full market value of that chattel from the defendant. I mean, the way to look at it is you've either taken it and absconded with it, or it has been destroyed by an act, by your act, okay? Such that you should pay for the thing in its entirety. On 87 in Pearson v. Dodd, okay? The most distinctive feature of conversion, second paragraph. The most distinctive feature of conversion is its measure of damages, which is the value of the goods converted. The theory is that the converting defendant has in some way treated the goods as if they were his own, so that the plaintiff can properly ask the court to decree a forced sale of the property from the rightful possessor to the converter. Okay? In the middle of 87 is the definition that I was trying to say from memory. An intentional exercise of dominion or control over a chattel which so seriously interferes with the right of another to control it that the actor may justly be required to pay the other the full value of the chattel.
I like the way you see it.
Yeah, okay. All right. Here, notice that there was no, the reason that Senator Dodd, that there was no conversion here is because the things, the materials that the defendants photocopied did not arise to property. Okay, at the bottom of 87, it's interesting to think about these things. The general rule has been that ideas or information are not subject to legal protection, but the law has developed exceptions. Where information is gathered and arranged at some cost and sold as a commodity on the market, it is properly protected as property. Where ideas are formulated with labor and inventive genius, as in the case of literary works or scientific researches, they are protected. In other words, they have risen to a thing that has value and is therefore property. Where they constitute instruments of fair and effective commercial competition, those who develop them may gather their fruits under the protection of the law. The question here is not whether appellee had a right to keep his files from prying eyes, but whether the information taken from those files falls under the protection of the law as property, enforceable by a suit for conversion, and the answer to that question is no. Okay, that's a very interesting, that's an interesting thing to think about as young legal scholars.
But doesn't that, like Watergate, isn't that kind of stuff?
That's what I was thinking too,
That's becoming valuable.
Well, I mean, but is it property though, right? You're talking about just bugging somebody. You're not stealing.
It says in there too, if some secretive information, proprietary stuff like that.
Right.
This wasn't.
This wasn't. That's right.
So that was part of it too.
And they put it back.
Yeah, they just.
And they put it back. They didn't take anything, right? The photocopy, the information itself did not fall into any of these categories. Yes.
What would be just a good standard example of like conversion that shows the difference between that and the trespass chattel?
Okay. So again, my buddy asked me to borrow the car. Okay. He says I got to go to Chattanooga. I'll be back Tuesday morning. In one instance, he goes, instead of going to Chattanooga and getting back Tuesday morning, he goes to Blacksburg and gets back Wednesday afternoon. So he's a day late, and he's putting more wear and tear on the car, but he's back one day later. That's trespass to chattel. If he takes the car and goes to Chattanooga and takes a left turn and then takes it all the way to Santa Fe, okay, and comes back 2 weeks later, that's conversion. Okay? It's just a matter of degree. All right?
Is it objective?
It's objective in whose eyes? Like, no, it's not really. It is. Yes, it is objective. That's what I'm saying. It's not really subjective. It's objective.
Circumstantial too, like depending on how much you're displaced by length zone.
Sure, absolutely. How much wear and tear on that car, right? How much have I been inconvenienced by the loss of the car? Generally, you're going to see it. I mean, in the test quest, it's going to get. You're going to know what you see. Okay, if the permission is only slightly exceeded, then it's trespass to chattel. If it's off the charts, then it's conversion. I've got 89 circled because it's got examples for you. All the notes, the page 89 and the notes on 89 and 90. What if, note 8, what if defendant went through the trash in the common area of an office building and took plaintiff's papers? That's a no. Okay, there's no action will lie there. If you've thrown it away, it's thrown away, and you've given up your interest in whatever the value of whatever it is. Therefore, conversion will not lie.
Is that like the full shred stuff? Some important
I shred things because I don't want you to read them, not steal them.
I mean,
I'm not protecting the property, I'm protecting the words.
I'm just saying, if someone's an undercover, like, garbage person or whatever, and goes through, you know, espionage.
Sure. I don't have interesting trash, so.
I don't.
Note 1, effective good faith on 91. I mean, all of these, 91 is all good. Circle 91. Okay? Note 2 is interesting as well. And let me tell you something. When you study for the bar exam, come circle back to note 2. But for our purposes, I'm not going to do that to you. Okay? Like an innocent purchaser cannot obtain title from a thief because the thief does not have title. The purchaser acts at her peril and may be sued in conversion by the true owner. Right? That's a third party, triple level, double cross kind of sneaky thing that bar examiners would do to you, but not me. Okay? There is something called the hot pursuit rule, okay? The seminal case for trespass to chattels, and I'm surprised, maybe I think it is. It appears in the privileges chapter. Somebody steals a stove. You are allowed to go to chase down someone who has taken something from you, as long as you demand it back and refuse, and the defendant refuses to give it back, you are able to use reasonable force to regain possession of your chattel, but it's got to be immediate. Like you have to, it's hot pursuit, right? You've got to, you've got to chase them down immediately, demand it back, and if they won't give it to you, then you can use reasonable force, which is a very low level, right? Okay. I want a Diablo burger and a Dr. Pepper. I'm in hot pursuit. That's a Smokey and the Bandit reference for all you people that are too young to remember. Right over here. Bandit, I'm gonna barbecue your ass in molasses. I want some hush puppies, Daddy. Oh, boy. Note at the bottom of 93, payment of the chattel's value by a converter to the original owner effectuates a common law forced sale of the chattel and precludes the original owner's further recovery of damages for subsequent conversions. I'm at the bottom. That was at the bottom of 93. Also, damages. Remember, it's the market value of the chattel at the time and place of conversion. Okay, that's the fourth time I've said it, so that should be enough. Okay. Note at the top of 95. Because of its origin as an action against the finder of lost goods, trover was limited to the conversion of things that were capable of being lost and found. It would lie for any chattel, but not for land, which in the eyes of the law could not be lost. Hence, the dispossession or withholding of real property could not be a conversion. However, nor could the severance of timber, minerals, crops, or fixtures attached to the land. Once those things are detached from the land, they become chattels and can therefore be converted. Timber especially. I'm first paragraph, subsection E on 95. Next paragraph, second sentence. It was first held that damages could be recovered for the conversion of intangible rights when they were merged and identified with a special instrument such as a promissory note, a check, a bill of lading, or a stock certificate, and that instrument itself was converted, this has now been generally extended to permit recovery for the conversion of rights of a kind customarily merged with such an instrument, such as those of a stockholder, without any conversion of the stock certificate itself. Okay, you can convert, a mutual fund, okay, or the ownership of a mutual fund without taking the actual stock. Note F, trover like trespass was founded upon the plaintiff's possession. From this has come the rule that anyone in possession of a chattel at the time of a conversion can maintain an action for it. Penultimate paragraph, recovery has been permitted even when the plaintiff's possession is wrong and in defiance of the true owner. Thus, one converter may recover from another. Again, I'm not going to do that to you. I got plenty of, yeah. Look at that, 7 minutes. And the Auburn Tigers take the field. All right? All right, again, that's it for this week. That's all I mean, listen, you may see at most 2 questions on trespass for chattels and conversion on the bar exam. 2. Okay? That is all I just told you everything you need to remember. Okay? If you can remember everything I said for the last 20 minutes, you're good with trespass to chattels and conversion. The folks on Tuesday night laughed when I said that. Y'all don't think it's so funny. If you can remember everything I said for the last 20 minutes, they were like, ha ha, sure, buddy. All right, y'all have a great Labor Day. Yes.
On your exams, how many issues are you going to see? I'm sure there'll be several, but there's going to be 7.
That's for me to know and you to find out. What? Huh?
I think that's going to for timing, because you might know everything.
No, I mean, you'll know, there will be, it's probably like 3, right?
Well, I don't know, 7 or 9.
No, it won't be that many. Okay, maybe 9 or 10. You'll have like, there'll be like 3 things you need to do. I will give you one, right? And maybe one little mini. We'll talk about that. I'll show you. I'll show you. Get there. Getting ahead of the game, Scott. Getting ahead of the game. Yes, ma'am.
Contract. We go into 101.
That's right. If you're not in your first, if you're not first termers and you don't have to come next week. This class, okay? If you didn't just take the LFC exam, you don't have to come. Yes, ma'am. Well, I would tell you your name and show you your badge. Oh, what's your name? Which one? Huh? Betsy? Gotcha.
Thank you.
Thank you. Y'all have a great holiday.
So for clarification,
holiday on Monday.
We don't have torts next week, so therefore no reading this week.
We don't have a reading this week. Y'all get